Okay. What's the date? It is September 20th, 2022 at 4:25 a.m. in the morning. I worked all day yesterday. Took a nap. And I'm at this. And you know the drill. Okay. All right. So this is one of these situations. Whereas if I was taking a shower and I had a webcam in my bathroom, you'd be like, ooh. Right? So I'm just going to work. Okay? Yeah. I'm going to show you how I do it. All right. I'm not going to say too much because I'm focusing. So, all right. Let's get on with it. I'm on number 21 with what I'm writing, and I am on number 17, a new page. Not going to say much, just going to stay focused. We're going to go through this fast. Fast. I figure if I do this for a couple hours, I should get a lot done because I don't plan on doing very much anyway. Just letting you see how I operate. Okay. That's what I'm working on. Just following up. Got to stay focused. I'm behind. Trying to do this as fast as I can. If you got something to do, I suggest you do it. In terms of, I'm not going to say much because I'm just showing you how I work at 4:37 in the morning. If you want to consider this work. This one's a tough one. Maybe if I talk it out. This is 20 on Judge Ross's dismissal. Andre Chorney is the plaintiff's son. I wrote, Andre Chorney is not the son of Judy Chorney. She alleges that he was apprehended improperly by the Ministry of Children and Family Development. That is true. So it requires no comment, right? However, she was forced to obtain counsel. Well, first of all, I guess that's true because there was a judge that told me to go back and put in a second application into legal aid in order to have a lawyer appointed to help with the paperwork to have Andre returned back home in that situation in my care. Not his mother's care, not his father's care, but in my care. To get a provincial court order returning Andre to her care. She points to this episode as another example of members of the public union sector targeting her. No, targeting the family. Andre Chorney is not the son of Judy Chorney, and nor was this incident the only harm that was, created Okay, Andre Chorney is not the son of Judy Chorney, and nor was this incident. It was more than an incident. BitChute has just gone down. I was just watching BitChute. I had SGT report playing in the background. Oh, you might be right. An error has occurred. What kind of error? I don't know. I'm getting BitChute. Could be your server. The truth about smallpox. Let's see if something's working. What do I want to listen to? I don't know. Let's see. We'll go to trending. I can't see. I got to stay focused on what I'm doing here. Hold on. Where am I? No distractions. I get distracted throughout the day. I'll come back. Okay, let me stay focused. Whew, there goes the ice. All right. Andre Chorney is not the son of Judy Chorney, and nor was the illegal apprehension of Andre Chorney I hate it when I forget how to spell a word. Oh, no, I lost the word. Illegal apprehension of Andre Charney. Appropriate. 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 Anyway, I don't know how to spell appropriate. I'll figure it out later. Illegal apprehension of Andre Charney. And nor was the illegal apprehension of Andre Charney appropriate. As, come on, I have a problem with my mouse. Takes up half my time. Can't freaking see it. Can't see the cursor. It's just little space, don't work. Stay focused. Andre Charney. Appropriate. Come on. Okay, stay focused. As the act itself caused lifelong injury to all members within the Charney family, and this is number 20. Oops. There's 23 for me. Okay. Let me fix this now. Make sure before I go on to the next one. So Andre Charney is not the son of Judy Charney, and nor was the illegal apprehension of Andre Charney appropriate, as the act itself caused lifelong injury to all members within the Charney family, to all members within Andre Chorney's family. I'm just showing you how I struggle. Like, this is pathetic, man. You don't know. Okay. Okay, now we're on to 21 of this. I'm trying to go fast. I'm only basically disputing where I find misinformation or misleading information, or I don't want to say false allegations in terms of character assassination through those false allegations, but just highlighting certain things to keep it simple, right? Because we know this is just basically one big Ferris wheel. I try not to get mad with this mouse situation. I couldn't imagine working on web pages right now. That'd be crazy. Because I can't see the cursor. Okay. Andre was returned to her care in 2014. Shmei Chorney, 22. Okay, so this is important. This is what I mean by misleading. We're on 22. Another of the plaintiff's daughters, Shmei Chorney, was pronounced dead on April 11th of 2018. Shmei had been in hospital for 9 days before she was pronounced dead. That is incorrect and misleading. She was pronounced dead 9 days after they took her dead body to the hospital, embalmed it, and then put it on a hospital bed for 9 days. And then turned off a machine that changed the color of her skin because they had little electro pads underneath it running their embalming solution through their new technology that they've got in order to try and give robots functioning skin. Because what else would you do it for? Long term. Short term was just to fool the family to make us think she was alive because of the color of her skin. But at the end of the day, she was dead for 9 days on that bed. He is trying to distract away from that by switching the timeline. Right? Pronounced dead. It is not disputed that Shmei died of a drug overdose. Again, being misleading. It is disputed. It's always been disputed. Shmei was murdered. He's being negligent by not acknowledging that murder by fentanyl exists. However, the plaintiff alleges that her daughter was murdered. Okay, he acknowledges it there. For that reason, and for the reason set out below, she seeks an order of this court requiring a full investigation. So the only thing that I really need to correct is the time of death. Right? I'm so glad I changed this keyboard. I can actually see the. I'm trying to keep it as simple as possible, to the point, single thoughts, single sentences. Okay? So what I wrote, Justice Ross, once again, is misleading to material facts by stating that Shimei Chorney was dead 9 days prior to April 11, 2015. This is incorrect. Have to save as you go, right? Otherwise, you never know. Oh. What the heck? Where are you going on me? Why is it doing that? Oh, I'm going to save this and close it and open it up again. Something happened. Let's see if we can try this again. Further, the plaintiff's allegations that the RCMP and the Fraser Health Authority provided false information about the circumstances of Shimei's death. Included in that allegation is the plaintiff's belief that the daughter actually died before she was admitted to hospital. The plaintiff alleges that the hospital then placed the dead body in a hospital bed for 9 days while the body deteriorated and decomposed. The plaintiff alleges that she could tell that her daughter had been embalmed on the first day she was in the hospital. I understand that Shimei Chorny was pronounced dead after certain life support machines were unplugged. That's pretty correct in terms of he started with his misleadment on number 22, but then covered his ass on number 23. Okay, so we go on to 24. The plaintiff also says that the family wishes regarding visitation to her daughter's hospital room were ignored. I understand that the family did not want Shimei's boyfriend. He was not a boyfriend. He was an ex-boyfriend who had been making threats on her life. I'm going to check on Amari. Okay, got a long way to go, so we got to get this shit done. Okay. read this again fast. Further, the plaintiff allegations that the RCMP, okay, read that. The plaintiff also says that the family's wishes regarding visitation to her daughter's hospital room were ignored. I understand that the family did not want Shmei's boyfriend to be permitted to visit her. She also alleges that her daughter's organs were illegally harvested by a syndicate of criminals. The plaintiff links that allegations to the province by paying the province uses hospitals by saying that the province uses hospitals to illegally harvest organs, using its employees to carry out heinous crimes, participate in witchcraft and Satanism, targets the Chorney family, and endorses gang stalking behavior against them. Justice Ross You know what? Keep it simple, like Lucy would say. Come on, man. And then we wonder why my eyes get worse. Well, what you gonna do? Be a dry fish out of water? I don't think so. Julian Johnson was not Shmei's boyfriend, but rather a ex who displayed violent tendencies that Justice Ross trivializes. Ex-boyfriend, be specific. But rather was a ex who displayed violent tendencies against Shimei Chorney and family, that Justice Ross trivializes. No. Because they keep trying to say that, quote unquote, she was a boyfriend, so therefore it made it okay for him to kill her. Somehow being a boyfriend makes it okay for them to kill you. No. Get the fuck out, motherfucker. I called for an investigation the moment I walked into the hospital room. And all I got back was a bunch of boobery. For weeks. And then it just got worse and it became a freaking gong show. And now I'm doing this. Because murder by fentanyl is acceptable in the province of British Columbia, Canada. Big bucks, big bucks. Don't get mad. It's 5:15 a.m. in the morning. It's too early to get up. Too early in the morning to get mad. Okay, stay focused. What I wrote there in response to Julian being the boyfriend, to which he was not. Get your facts straight, Judge Ross. Julian Johnson was not Shimei. Hold on. I'm going to put her last name in there. Chorney's boyfriend, but rather was an ex-boyfriend who displayed violent tendencies against Shimei Chorney and her family that Justice Ross trivializes. I may come back and do something with that, but for now, the thought is there. Julian Johnson was not Shimei Chorney's boyfriend, but rather he was, because he's dead now. What's new in the province of British Columbia, Canada? But rather, he was an ex-boyfriend who displayed violent tendencies against Shimei Chorney and her family, to which, and her family, who displayed violent tendencies against Shimei Chorny and her family. To which the hell is going on, man? To which, comma, Justice Ross trivializes. Number 24. On his. Further, the plaintiff alleges that the RCMP and Fraser Health, or did I not just do this one? Maybe I got it wrong. No, that one was right. We're on 25. The plaintiff alleges that there has been no proper police investigation into her daughter's death. In addition, she says that the medical records have been falsified to indicate that the plaintiff, as Shimei's mother, refused to donate Shimei's organs. That is true, but they don't care about that, people. They don't care. (26) The plaintiff seeks an investigation into these allegations as well as access to Shimei's medical records. I have some of her medical records. I don't have all of her medical records. I don't have them from the clinic. I don't have them from the prenatal clinic. I don't have them from the abortion clinic. But I do have her hospital medical files. So, in part, it is true. What happened here? What did I do? What the heck did I just do? That's a whole different page. Okay. Amari Johnson, number 27. Amari is the plaintiff's grandson and the son of Shmei Chorny. 28. I am informed that Amari was born with cerebral palsy. The plaintiff complains about the medical care that Shmei received leading to and at the time of his birth. I understand that he was born at a hospital within the Fraser Health Authority. The plaintiff says that the hospital records relating to his birth have been edited. This is the other element of correction of hospital records that the plaintiff seeks in the notice of civil claim. No, that's not true. He's just twisting things around. Shmei's medical files were falsified. Although in Amari's medical files, there is a copy and paste in there that's misleading, but only in relation to trying to discredit the mother so that they could hide the fact of the birth injury at the time of his birth. However, that birth injury occurred. Okay? So I guess in that sense, what he wrote is true. So just keep it simple. Move on to the next. Because there is discrepancies, right? And yes, some of those things need to be corrected. Okay, I remember. Right? Because they're trying to suggest through Amari's medical files that Shmei was a drug addict, and therefore that's why he came out with cerebral palsy, which is untrue. Other claims. 29. In addition to the events in the categories listed above, the plaintiff makes other allegations in the notice of civil claim spanning the period from the 1990s through to the present time. Those allegations include the removal of the Chorny Those allegations include the removal of the Chorny family from social assistance and other public programs beginning in the 1990s. That's not true. I was illegally cut off of welfare in 2003. Under legislation that wasn't even in effect. Although they took away my business license after I got a business license, maybe, was it in the 90s? No, it would have been in the 80s. They took away my business license in the 80s because they said I couldn't have it. Because, manufactured poverty, right? But that's neither here nor there. Justice Ross is being misleading to say that Judy Chorney did not qualify for social assistance in the 1990s, whereas the material facts are as is, comma, Judy Chorney was illegally removed from social services under legislation that wasn't even in effect in the year in the month of January 2003. Well, what number was I reading? I don't even know. I need to check as I go because I already figured out what number I was reading. Okay, so that's 29. In the 1990s, she says that this series of events discloses a pattern of conduct by public sector union employees against her and her family. Okay, so what I wrote is Justice Ross is being misleading to say that Judy Chorney did not come on, I can't stand this mouse, man. It takes up half the time. This is where you just have to be patient and not get mad. To say that Judy Chorney did not qualify for social assistance in the 1990s, whereas the material facts are as is. Judy Chorney was illegally removed from social services, social assistance, from social assistance. Come on, man. Assistance. Okay, so Judy Jordy was illegally removed from social assistance under legislation that wasn't even in effect in the month of January of 2003. I don't need to go into details. I just need to correct the facts that he's trying to screw up, right? Because that's what he's doing. He's just mixing things up. And that would be number 26 for me. Come on. All right. Oops. Shit. That's number 29. Oh, come on. Where the hell are you typing in? Go away. In the month of. Boy, oh boy, oh boy, oh boy, oh boy, oh boy, oh boy. Don't get mad. This is where you're having that seizure, and you just have to go through it, because if you don't go through it, you won't. You understand what I'm saying? This is kind of what it freaking fucking feels like for me. Maybe that's what Shimei's dream is telling me. Just, it feels like you just like, ooh, so annoying, man. The mouse is just going wherever, because the cursor, I can't see everything. It's so hard to see, right? So, not only that, but the freaking thing flies around. And I changed it. I replaced the mouse with a different mouse. But a lot of it has to do with my eyes. And not enough workspace in terms of using a mouse, right? I'm just like, and the screen is over here, so it makes it worse. I can't even find it. Big waste of time. That's all it is. Position of the defendant. 30. The defense argument is multifaceted in order to address the variety of claims made in the notice of civil claim. John Duncan, 31. As part of the evidence on this application, defense counsel tendered pleadings and prior decisions of this court in other actions commenced by Ms. Chorney. Those actions have an influence in my decision. 32. In action number S171469, the plaintiff sued the Fraser Health Authority. I note that this is one of the two actions referenced in the plaintiff's notice of civil claim. See paragraph 14 above. The action related to John Duncan and the power of attorney. He's forgetting to say enduring power of attorney, but we'll let it slide, okay? Because we're just focusing on the main points here. Unconditional love, Lady P. Sending unconditional and genuine love, beautiful. I just got my beautiful granddaughter off to school. I appreciate you for taking care of your beautiful grands. Good morning, good morning. I'm working on this appeal. It is now 5:38 my time. In the notice of civil claim in action which would be CIBC Bank, the plaintiff alleged that hold on a minute. Yeah, same one, Fraser Health Authority. The plaintiff alleged that Fraser Health Authority provided negligent medical treatment to Mr. Duncan and further that the negligent treatment led Mr. Duncan to being removed from the plaintiff's home. No, he was not removed from my home. He keeps doing this because he's trying to make it sound like there was something wrong with me. He was removed from the healthcare system that he had been in for 39 days, 40 days. I added up the numbers, 40 days, something like that. I have to add them up again just to be double sure. I'll write them in because it's bullshit. They took him out of the temporary care ward that he had been in within the healthcare system, we'll just say 40 days. And then when they got off the ferry, they immediately went to the emergency ward at the Victoria General Hospital because John practically died. They did not remove him from my home. They took him from a care ward that he was being held captive in. And then they drugged him up so that he would sleep. And I guess he had a reaction because it almost killed him. So much so that they had to rush to the emergency ward. And then they kept him for 2 months or more as they denied access to have his family come visit him. Why do these judges and the government keep playing head games with me on this, people? Why? Stay focused. Don't get mad. Want to cry now? Further that the negligent treatment. Okay, so we're looking at number 33. Of course, Isn't that a satanic fucking number? Justice Ross continues to import his own opinion as to where Mr. Duncan was removed from, being that Mr. Duncan was in the care of Fraser Health Authority for I had a freaking calendar here. I don't know where it went. I'm just going to put down 40 days right now. It's either 39 days or 40 days, or maybe 41 days or 42 days. I'm just going to put 40 days. I'll come back and correct it later. Justice Ross continues to import his own opinion as to where Mr. Duncan was removed from, being that Mr. Duncan was in the care of Fraser Health Authority They want that cortisol to keep, they want you sick, they want you crying, they want you sorrowful, and then they sit up there and they deny the fact that this is what they want, which is classified basically as loosh harvesting, which is a form of satanic practices, because for whatever reason, that's how they gain strength. Duncan was removed from being to where Mr. Duncan was removed from being that Mr. Duncan was in the care of Fraser Health Authority for a period of 40 days. I'll double check on that. Justice Ross continues to import his own opinion as to where Mr. Duncan was removed from, being that Mr. Duncan, I suppose I should put a comma in there, being that Mr. Duncan was in the care of Fraser Health Authority for a period of 40 days. Further, the actions of the health authority allowed Mr. Duncan's sister to take over as his attorney under a new power of attorney. The plaintiff further alleges that the action that she had not seen Mr. Duncan since 2015. So let's read this sentence again. This is number 33. Okay. In the notice of civil claim in action number, which is Fraser Health Authority, the plaintiff alleges that the Fraser Health Authority provided negligent medical treatment to Mr. Duncan and furthered that the negligent treatment led Mr. Duncan to being removed from the plaintiff's home and care. No, he was not at home and he was not in my care. That's what you call doublespeak. Justice Ross continues to import his own opinion as to where Mr. Duncan was removed from, being that Mr. Duncan was in the care of Fraser Health Authority for a period of 40 days before, let's finish the sentence, before he was medically kidnapped, which is a federal offense, which is a federal offense. That's why they don't care what happened to him after he left the old Yale Center, because they don't want to go after the criminals that medically kidnapped him and locked him up and put him in fucking jail and clean out the swamp, okay? It's a federal offense to medically kidnap people. It's a federal offense to hold them against their will. I'm pretty sure it's a federal offense to drug them up, put them in a fucking hammock, put them in the back of a van, jump on a ferry, let them sleep at the bottom of the ferry in the carport, and then get off the ferry and then drive to the freaking emergency ward and tell lies and say that's how they found him. As you got some judge trying to suggest that they took him out of my home, which is bullcrap. And because they won't do a proper investigation, all they do is just keep accusing me of being convoluted or whatever it's called. Because they're negligent. It's like going into those glass houses where you go into a glass house and right? You don't know which is the real door and which isn't, because everything looks the freaking same, because it's all nothing more than a damn illusion. That's your justice system in British Columbia, Canada. Seriously, man. Like, you don't know. I get so freaking tired of this crap. Like, it's so fucking fake. So fake. So fake. $34. Within that prior action, the defendant threw an application to strike the pleading and dismissed the plaintiff's claim. The defendant's application was granted by Justice Bowden on December 7th of 2017. Justice Bowden found at paragraph 8 that it is plain and obvious that the claims that I could discern from the notice of civil claim would fail, even if the allegations, even if the alleged facts are assumed to be true. I don't know what to say about that one. 35. I note that Justice Bowden stated in his oral reasonings at paragraph 5, she did not provide the court with a copy of power of attorney. That is not true. He asked to see what I had. I passed it to him, and he looked at it. And then he gave it back to me. He said I may or may not have, and then he dismissed it. So, what he should have done is he should have asked me to, after the session of court, go to the court registry and submit it to the court registry so that it was, I guess you could say, legitimately on the court file. Okay? They turned it into a mini trial before I even had a chance to submit my documents. And that's the only reason they got away with the crap. So, how do we do this? Hello, Irene Williams. Good morning, good morning. So we're on 34, so that needs to be corrected. Just trying to catch my cursor. I have to line it up before I can print. Okay. So, she did not provide the court with a copy of power of attorney, as it was a power of attorney that related only to financial matters. It would not give her standing to proceed in court against the Fraser Health Authority on his behalf. This bullshit is a straight up freaking lie. Okay. So, again, Justice Ross is again importing misinformation by stating that Judy Chorney did not provide evidence that she held two power of attorneys, with one of them being enduring power of attorney since 1990, and was and is still in good standing. Because you have to remember, I've never been taken off as enduring power of attorney or power of attorney in a legal sense with Uncle John. And there is still an account with Uncle John at CIBC Bank that requires Uncle John's signature in relation to Andre Chorney. I don't know how much a dead man can have so much power, but Uncle John's got so much power that he's got these freaking judges cowering in freaking corners, peeking out from a door. Seriously. This makes me so mad. Like, these guys are like stupid. They are not judges. They are the court jesters, the clowns, the ones with those little funny things with the little bells that hang, you know? With their little funny clown suits on. Justice Ross is again importing misinformation by stating that here we go again, trying to catch this stupid freaking cursor. Come on, bitch. Come on, where are you? Don't get mad. Justice Ross again. Justice Ross is again importing misinformation by stating that Judy Chorney did not provide evidence that she held two power of attorneys, with one of them being enduring power of attorney since 1990 and was in, okay, we don't have to say, just say 1990. We don't get, okay. Power of attorney since 1990 and 1990 with the other, with the other being power of attorney since 2001. Keep it simple, right? Well, actually, it's 35. What am I doing here? Scratch that out. It's number 35. Correct that. Oh my God! Get so mad with this mouse. Do you see how long I waste just with this stupid mouse? It's because I can't see as clearly as I used to. Okay. Justice Ross is again importing misinformation by stating that Judy Chorney did not provide evidence that she held two power of attorneys, with one of them being, attorneys, with one of them being enduring power of attorney since 1990. And with the other being power of attorney since 2001. Justice, this is a new number, number 29. Justice Bowden ignored the evidence that was presented to him at the time in question. Justice Bowden ignored the evidence that was personally, I'm going to put down personally, because it got handed to him personally, with me standing there looking at him, taking it and looking at it, and then Justice Bowden ignored the evidence that was personally handed over to him by court staff as presented to him at the time in question. That was presented to him at the time in question. So that's number 35. '28 and 29. Not that they'll pay attention to it, because they won't. Because they don't give a shit. Like I said, I don't even think they're real. Wait till we get into those videos. Remember that corner behind that closed door with Sierra at John Hart's house? And I got just a little flash of that individual with her completely white face, with all those electrodes in her hair that was coming in under exposure. At the time in question. So I'm going to read those two sentences because they go hand in hand. And it's in relation to them saying that I provided no evidence to suggest that I had enduring power of attorney and power of attorney. They're trying to blow it off like I never provided any evidence, which is a bunch of crock. This is my response to it. Justice Bowden, again. Justice Ross is again importing misinformation by stating that Judy Chorney did not provide evidence that she held two power of attorneys, with one of them being enduring power of attorney since 1990, and with the other being power of attorney since 2001. 29. Justice Bowden ignored the evidence that was personally handed over to him by court staff as presented to him at the time in question. As provided by, okay, hold on a minute, staff as, we'll just add in a little more, over to him by court staff as provided by Judy Chorney and as presented to him at the time in question. So now they're going to call me a liar. $36 on his. In this action, the plaintiff argues that this paragraph contains factual error, which I just addressed. She says that she had enduring power of attorney. Hence, my understanding is that she brings this action against the Crown to have that factual matter cleared up and thus have her claim heard. The defendant says that this is an obvious, improper collateral attack on Justice Bowden's decision, and thus it is an abuse of process. Discussed is an abuse of process. I discussed that submission below. So you can lie, and if the government says, well, just ignore it, because we don't want to accuse the judge of lying because, he's godly, then so be it. I wrote a paragraph 10 to 11. Just hold on. Okay, I'm on number 36. So Crown to have that fact matter cleared up and thus have her claim heard. The defendant says that this is the obvious improper collateral attack on Justice Bowden's decision, and thus it is an abuse of process. I discuss that submission below. Number 37. Continuing on with the narrative, after the plaintiff's action against Fraser Health Authority was dismissed by Justice Bowden, Ms. Chorney sought to appeal that decision. She applied to the Court of Appeal for a no-fee order on February 28th of 2018. Justice Savage dismissed the plaintiff's no-fee application on the basis that her appeal had no merit and was bound to fail. He wrote at paragraph 10:11, 10. In my view, this appeal is one that is bound to fail. Ms. Chorney's pleadings discloses no prospect of success. Ms. Chorney lacks understanding to bring an action for alleged harm done to Mr. Duncan and family. It's not just John, whether he is alive or dead, which on the pleadings is not clear. He was alive at that time. if he were alive and if she only had a power of attorney, that would not be sufficient to support these claims. Do you see how that judge ignored the fact that I had enduring power of attorney? Okay, I'm not even going to go there with it right now. If he was deceased, the action would have to be commenced or on behalf of his estate. If he was incapacitated, she would have to be appointed his guardian ad litem. In the hearing today, Ms. Chorney advised that Mr. Duncan is in fact deceased. No, that's not true, because he didn't die until January of 2018. I'm pretty sure it was January. I guess I should do an obituary on that, right? I'll do that later. 11. And you see, I went to the public guardian and trustee and I requested an investigation into it. And of course, they didn't phone me to let me know. And when I did phone and I finally got to speak to somebody to see if they'd even done it, they basically were rude at me and then hung up the phone and said they found nothing suspicious, and they hung up the phone. I highly doubt that they did an investigation on Eleanor Gilding, the manager of the province's immunization program when it comes to the healthcare workers, because that's basically who medically kidnapped Uncle John in partnership with anybody else that helped her to do it. Okay? And she sure in hell didn't go to the public guardian and trustee and put an application in to be Mr. Duncan's adlin, whatever it was, to dispute against me. Okay? She just did everything through the backroom deal and paid out a bunch of money along the way, being that she was rolling in a whole bunch of freaking dough and she could afford to do it. All right? So for them to expect me to do something that woman should have done in the first place to make everything legitimate is irresponsible on the court's part. Okay? So even if I was to write that it was Eleanor Gilding's responsibility to take it to the, and appoint herself as, right, they're still going to ignore it because they're protecting her people. They're protecting her and people like her, and they're protecting the system that they have in place. For whatever reason, they're protecting her and the system. And that's why that building sits freaking empty. Whereas if you go to a temporary care ward, you're going to find old person after old person, and many of them being Caucasians. You're not going to find too many Punjabis in there because, it's organized religion that molds social engineering when it comes to certain things that happen in the province in terms of those systems. Old white people, for the most part, the baby boomers, that generation is just an income for the predator class to exploit. And that's why they need Eleanor Gilding, because she's good at it. And they only play the public guardian trustee card when it's convenient for them. Okay? This is like calling the kettle black. That's what Eleanor should have done. She should have taken me through the public guardian and trustee to court and had herself appointed with the blessings of the guardian and public trustee to say, yeah, you have the right to represent John Duncan, and we are going to we're going to legally remove Judy Chorney with enduring power of attorney and power of attorney. Step down, Miss Chorney, because now Eleanor Gilding would be appointed that ad lim, while the public guardian and trustee would monitor her people. They would monitor her people to make sure that whatever she was doing with John's inheritance was being done with ethics. But that's not what happened, and that's why we're here. So, how do I address that? 11. If, on the other hand, Miss Chorney brings an action on the basis of harms done to her, done to the family, the law is clear that Fraser Health Authority must owe her a duty of care, and she must clear that Fraser Health Authority must owe her a duty of care, and she must allege facts demonstrating that they breached that duty of care. The pleadings are prolific, but that said, the facts alleged in the pleadings do not persuade me that the judge erred in finding that the claim discloses no reasonable prospect of success, as it is not alleged that Fraser Health Authority owed her a duty of care and breached that duty. They did, though, because they didn't follow their own rules, regulations, and mandates within the various legislations. Oh my God, I'm breaking out in BO because this upsets me so much. You don't know. Okay, so anyway, we have to address this. I have to find a way to address this somehow, some way. This is 28. $37. This is number 37. Justice Bowden was Justice Bowden what do we got going here? Good morning, Lucy. I'm just working. How long have I been on here for? Oh my Lord, 2 hours. Just taking a shower, splish splash, taking a bath, doing my dishes on a live stream. Now I'm washing the floor when I'm not washing the wall. Oops, I got laundry in the hall. Court of Appeal. Okay. Come on. Think. Standing to bring an action. Justice Bowden. Justice Bowden. Ignored. I already wrote that. Judge Ross again importing. Judge Ross is again importing misinformation by stating that Judy Charney did not provide evidence that she held 2 power of attorneys, with one of them being enduring power of attorney since 1990, and with the other being power of attorney since 2001. So is this in relation to Justice Bowden or Justice Savage? Justice Savage dismissed. Justice Savage dismissed my appeal for no fee application based on misinformation that Justice Bowden provided. It's like gang banging. Yeah, it's like gang banging by a bunch of freaking judges, each one taking their turn. Like the slimy mother boo-boos they are. Because you got to be pretty freaking slimy to do gang banging, okay? It's slimy. If you've been raped, you know what I'm talking about. In reference to Justice Savage, I know too many of us women do know. Yeah. There's a reason why they call it gang banging. In reference to Justice Savage and his reasoning for judgment, he too was being misleading to ignore material facts I think I'm going to need a break. In relation, this is a tough one. In relation to Justice Savage and his reasoning for judgment, he too was being misleading to ignore material facts that Judy Chorney held two separate power of attorneys that were not removed from her in any legal way. So therefore, she was not required to go through the public guardian and trustee to follow up on her duties towards Mr. Duncan. That onus fell on Eleanor Gilding, and I'll put that there. That onus fell on Eleanor. Oh, God. Eleanor Gilding and or on Fraser Health Authority to remove Judy Chorney from her positions. Okay, let's read it now. That's all I'm going to say. In reference to Justice Savage, because it's in relation to number 35. Well, it's 35 for me. It's not 35 here. It's 20. What am I doing? Oh my God. Yeah, here we go. 37. Number 37 here. So this is the one right here. Okay. In reference to Justice Savage and his reasoning for judgment for judgment, he for judgment. What's going on here? In reference to Justice Savage and his reasoning for judgment, he too, comma, he too was being misleading to ignore material facts, comma. Oh, come on. Material facts. I'm not going to get mad. Judgment, he too, okay. In reference to Justice Savage and his reasoning for judgment, he too was being misleading. Okay. In reference to Justice Savage, he too was being misleading in his misleading in his judgment oh my God. To reference Justice Savage, to reference Justice Savage he too to reference just okay. I'll take my freaking mouse and just throw it. I just want to scream. Ooh. In reference to Justice Savage, I mean, how the just no, calm down. Don't cry. Don't fucking cry, man. This fucking mouse is making me mad. Now I'm getting really irritated. Oh my God. Okay. In reference to Justice Savage, comma, he too was being misleading in his judgment. To ignore material facts that Judy Chorney held two separate power of attorneys that were not removed from her in any legal way. So therefore, she was not required to go through the public guardian and trustee to follow up on her duties towards Mr. Duncan. That's one complete thought. I wasn't required to go to the public guardian and trustee and put an application in to represent John with something I already had. Okay? And because they don't want to acknowledge that I had the power of attorney and enduring power of attorney, they're making it sound like I had no power in terms of if I wanted to do anything, I should have went and, oh, please give me, no, I already had it, people. It was the bank's responsibility to take me to court. It was Eleanor's responsibility to take me to court. It was freaking Fraser Health Authority and their staff or whatever to take me to court to remove me from what I already had. This is where the judges are misleading and are twisting and are avoiding. Oh my God, I just lost it. Where the frick hell is it? Here we go. Come on. Where are you? Do you see how much time I waste just chasing the mouse? I used to make web pages. It would take me a century just to make a web page now. Okay, so I'm going to read that again, and hopefully it will be suffice. I know too many of us women do know. Lucy, wish I was there to help with it. You need a secretary. Oh, I know that would be just grand. Lucy again, just to dictate or shuffle paper is a difficult thing to write all that. Well done thus far. Yes. Okay. So let's read this because this was kind of tough. So in response to them saying whatever it is that I needed to do that I already should, blah. Okay. This was my response to it, which was number 35 on his oh no, number 37. Number 37, Judge Savage here. Okay. So, in reference to Justice Savage, he too was being misleading in his judgment to ignore material facts that Judy Chorney held 2 separate power of attorneys that were not removed from her in any legal way. So, therefore, were not removed from her in any legal way. So, therefore, the comma should be after therefore, not before it. I'm pretty sure. But then I'm not no guru when it comes to the English language either. Where are we? Come on. So, therefore, she was not required to go through the public guardian and trustee to follow up on her duties towards Mr. Duncan. And that's true. I was not obligated to go to the public guardian and trustee to remove myself as enduring power of attorney and power of attorney to Mr. Duncan. It was the responsibility of Fraser Health Authority, being that they wanted to put their nose right into it, right along with Eleanor Gilding and CIBC Bank. They all 3 of them could have taken me to court, people, and this issue wouldn't be happening. But not one of them did it because they were sneaking around thinking that they could just tell me to F off, go get myself a lawyer, deny access to information like just whatever, right? I'm not going to get myself worked up. We know it's just a gong show. Okay? Oh, come on. Okay. And then oh, come on, man. The burden to remove Judy Chorney from either power of attorney The burden to remove Judy Charney from either power of attorney was on Fraser Health Authority or on CIBC Bank or on Eleanor Gilding. The burden to remove Judy Charney from either power of attorney. Okay. The burden. I'm going to spell burden. Here we go back to chasing this bloody mouse. Can't see it. The burden to remove Judy Charney from makes me want to freaking cry, man. Now I'm getting mad. Fuck. Oh, God. Remove Judy Charney from power of attorney or you have to write it down enduring power of attorney because they ignore it. I hate life, people. I fucking hate life. This is not life. This is hell. The burden to remove Judy Charney from power of attorney or enduring power of attorney was on Fraser Health Authority or on CIBC Bank or on Eleanor Gilding's well, you don't want to say shoulders. The burden to remove Judy Charney from power of attorney or enduring power of attorney was the responsibility of was the responsibility of Fraser Health Authority or CIBC Bank or on CIBC Bank or on Eleanor Gilding. One complete thought, okay? Here we go. The burden to remove Judy Charney from power of attorney or enduring power of attorney was the responsibility of Fraser Health Authority or on CIBC Bank or on Eleanor Gilding via through court order. But they didn't want to do that because as soon as they did that, people, they didn't. Let me just write that down and then I'll explain to you why they didn't do that, okay? And why they're trying so hard to cover up what they did. Via court order. Now, they could have just taken it to court and went in front of a judge with the signature of two doctors stating that John was incapable of managing his affairs and therefore his estranged sister wanted to take it over because, she had all this money that she was holding for him for 14 months without telling him, and that, she wanted to make sure that he was going to be looked after now that he was cuckoo. They didn't want to do that, okay? So they didn't bring in doctors to sign that two signature to make him, mentally disturbed, where he would have an ad lim or whatever it's called appointed to his estate, okay? Because they didn't want whoever was managing the estate from a third party sense tapping in and controlling the money people in terms of taking their fees and telling Eleanor what she could not spend it on. Eleanor wanted it all for herself. And because it was so much money, it was nothing for her to, put out a bribe here and pay out a bribe there. And who knows? Okay. Because let me read this again, right? This is number 31 on what I'm typing out in relation to number 37 of what I'm reading here. And the burden to remove Judy Charney from power of attorney or enduring power of attorney was the responsibility of Fraser Health Authority or on CIBC Bank or on Eleanor Gilding via court order. All three of them could have taken me to court at one time to remove me. One of them could have taken me to court at one time and removed me. And then they could have went on their very merry way because, chances are the judge would have been bought off in that situation and would have sided with them and said, get lost, Judy. And then, but through that process, because John would have had to been deemed as incapable for a judge to even get involved, that's when, by law, to the public guardian and trustee corporation and their acts and mandates and rules and all that other crap, they would have just automatically assigned John that ad litem or whatever it's called to supersede all the greedy family members in the family that wanted to put their fingers into John's assets and steal them. They would have put the brakes on it. But instead, they allowed Eleanor to do it. Because when I put an application in via through the request of Paul Evans to file a complaint and to ask for an investigation with the public guardian and trustee, to which I did, right? They ignored it, people. They played it off like John was safe. And then they just hung up the phone on me. Literally, they hung up the phone on me. Because somehow, some way, they're involved too. They cherry pick what they want to choose to represent. And because we're dealing with somebody that sits on boards of, medical decision making when it comes to whatever, right? Or they're managers to a provincial immunization program for the province, it's like This woman has a free pass to do whatever she wants. She's got the bank by the balls. She's got Fraser Health Authority by the balls. She's got the government by the balls. How can one woman that goes around stealing money and ruining people's lives have so many people within, by the balls? Because that's basically what Eleanor has done. She's got everybody on lockdown doing her dirty work for her so that she can sit there and not be held to account to the damage, the psychological damage, the physiological damage, the physical damage, just the death, the harm, the injury, the gang stalking, just all of it. Everything that's resulted from the time that she instigated the medical kidnapping of Uncle John. And because the bank thought that I was stupid, Fraser Health Authority thought I was stupid, Eleanor Gilding thought I was stupid, all these fucking lawyers, jackass lawyers, jesters that I come into contact with think I'm stupid. They didn't want to do it the legal way. And they think just by ignoring the material facts as it's being presented to them, whether it's coming in through the court registry or whether it's going through the, from standing where you are with, here's the lawyer, there's the staff, and there's the judge, and you put the paper that way, and it's given back to you after he looks at it, it's still legitimate. It was his job to tell me to file it with the court registry, but he didn't want it filed because he doesn't want it acknowledged. So, yeah, they're all jacking each other off here, people. This is like gang rape, okay? Let me have a turn, fucking her over. Let me have a turn, fucking her over. Let me have a turn, fucking her over. Here, we'll just grease her up a bit more and fuck her over there, okay? Like, it's bullshit. It's bullshit. It's bullshit. Complete fucking bullshit. You don't want people to have power of attorney, enduring power of attorney? Then take them to fucking court. That's what you do. But none of them took me to court. Not one. But they're telling me I needed to go to court and appoint myself as something when I already had it? Yeah, okay. Okay. Anyway, that's enough of this. I'll just read those last two sentences because those ones kind of got me mad. And I'll pick up later. Or maybe I'll go have a coffee and come back and work a little longer because the kids are still sleeping. I'm on number 35. That was number 29. 29 to 31. So I'll read from 29 to 31 of what I wrote. And that's pretty much it. Justice Bowden ignored the evidence that was personally handed over to him by court staff as provided by Judy Chorney and as presented to him at the time in question in relation to number 35, what he's got here, right? 30, in reference to Justice Savage, he too was being misleading in his judgment to ignore material facts that Judy Chorney held two separate power of attorneys that were not removed from her in any legal way. So therefore, I'm not going to put she, I'm going to put Judy Chorney. So there's no misunderstanding. I was not obligated to go to the public guardian and trustee and ask them if I could represent John. It was his sister's responsibility to go to the public guardian and trustee and get a judge to agree that she should have been that in terms of, can I represent John? Now that I've been holding his money for the last 14 months, I kept it nice and fucking safe. Nobody knew that he even had it. You can trust me, Your Honor. Don't worry. I'll make sure I spend it all in the right way to protect my brother from what? What? 40 days in Fraser Health Authority? In their hospital? In their temporary care ward? Only to be rushed immediately to an emergency ward across into Victoria Island there? Half dead? Like bullshit, people. Total bullshit. Like, who does that? Who feeds elderly people medication to make them go to sleep, put them into a fucking hammock, put them into a van, get on a ferry, get on the other side, and then rush straight to the emergency room? And then try and blame somebody else for him being in the state that he was in when he showed up at that fucking emergency room. After he's been in a healthcare facility for 40 days. Eleanor Gilding does that. Fraser Health Authority staff does that. CIBC Bank condones that. So does the province of British Columbia, Canada. They think that's just good business. Prove me wrong, Justice Ross. Prove me wrong, Justice freaking Savage. Prove me wrong, Justice Bowden. Prove me wrong. They can't, though. You see, that's the thing. They can't prove me wrong, people. All they can do is try and keep it fucking hidden. And they know it. And then they'll sick their freaking hounds on me. You know, just add on to that gang stalking freaking soul train, right? Who's next? Who's next, people? Who's next? And then come back and say, oh, no, we don't gang stalk you, Miss Charney. No, not you or your family. No, because we're so godly. And so are our friends. And so are the people that we employ. Okay, I'm going to read this sentence again. Save it first, just in case. In reference to Justice Savage, he too was being misleading in his judgment to ignore material facts that Judy Charney held two separate power of attorneys that were not removed from her in any legal way. So therefore, Judy Charney was not required to go through the public guardian and trustee to follow up on her duties towards Mr. Duncan. 31. The burden to remove Judy Charney from power of attorney over or enduring power of attorney. Try this again. The burden to remove Judy Charney from power of attorney or enduring power of attorney was the responsibility of Fraser Health Authority or CIBC Bank or on Eleanor Gilding via court order. You can't get it any more simpler than that. The burden was on them to take me to court, not to commit bank fraud by kicking out my card with 3 different tellers and then going after my family members where they start dying or they become permanently injured for life because they're booked in for some research study over there at the time of their birth before they're even out of the womb yet. Bullshit. Total fucking bullshit. Okay, so we're almost halfway through what he wrote. You can see what I go through, how I do it. I am the one that's doing it. I don't fake the fucking funk here, okay? Today's only Tuesday. I'll make an effort to work on this again today at some point, but of course I've got a lot of, household duties. So we'll see how it goes. I'll probably make another coffee and run a few more sentences because you can see what I'm doing. I'm just picking out areas where they're being basically misleading or they're falsifying whatever it is that they're trying to falsify to distract away from the fucking facts and what should have happened. Okay? To avoid acknowledging what did happen. So where are we? We got the 4 people watching. Burden. Okay, let me see. I know too many of us. Okay, Lucy, just to dictate or shuffle paper. Yeah, that's basically what these judges do. Yes, was criminal how it went down. Very criminal. Very, very. I will use big letters. Okay, easier to read. Burden. Wow. All right. So how many hours? Almost 3 hours here. So I'm going to take a break. And like I said, I will try and go through this as fast as I can. Type a few more because it's fruitless. But it's important to take the test. This is the seizure part with Shimei. Because if you notice, I'm Twitch. When you start to go blind, Ray Charles, right? Who else is that other guy? They tend to rock. You know what's that? Blind people, they tend to rock. Well, I don't know if you've been noticing, but I've been rocking more. I've noticed it. Right. But it is what it is. Okay, so I'm taking a break now. All right. Thank you for being there for me. I do appreciate it. Very much so. You don't know how much. We'll get through this together. As Tammy would say, we're towing that line. Okay? Just remember that. We're towing that line. Towing that line.